Hello, everyone, and welcome to this Lexology webinar presented by IAM. My name is Jacob Schindler. I'm IAM's Asia editor, and I'm joining you all from our office here in Hong Kong. AI is producing seismic changes across a range of industries, but patent offices around the world are still grappling with the extent to which inventions involving artificial intelligence are patent eligible. So what is the current state of play? Well, we're very pleased to have two speakers from Sonoda and Kobayashi intellectual property law on hand to tell you about how AI patentability standards are developing in key jurisdictions around the world. In just a minute, you're going to hear a brief review of laws and rules around AI eligibility, as well as real-world examples of AI patent families filed in the United States, Europe, Japan, and China. But before we begin, just a few quick housekeeping points. First and foremost, please use the online question tool to pose any questions that you have throughout the presentation, and we will get to those when we have the opportunity to. Second, if you have any audiovisual problems during the presentation, please let us know using that same tool, using the online question tool, and we will do our best to help you resolve those. And finally, this session is being recorded. The recording and the accompanying slides will be posted online, and we will send a link to all the webinar attendees. So we do encourage you to use that link and send it to any colleagues who you think may be interested in the content. With that, I'm going to introduce today's presenters from Sonoda and Kobayashi. A little later, you'll be hearing from the firm's co-founder and managing partner, Dr. Yoshitaka Sonoda. Dr. Sonoda is fluent in both English and French, skills which were acquired as a researcher at the Saclay Nuclear Research Center in France. He spent 3 years there after he was awarded a PhD by the University of Tokyo. He was a researcher at Hitachi and joined the field of IP law in 1987. He's practiced across various aspects of IP law over more than 30 years, including the past 19 years at Sonoda and Kobayashi as managing director. Dr. Sonoda handles appeals, invalidations, and infringement proceedings for clients from France, Denmark, Germany, and the United States before Japanese courts. But first up this evening, you're going to hear from US Patent Attorney and US Attorney at Law, Sarvajit Patil. Sarv has been a New York State licensed attorney at law and a US registered patent attorney since 2011. He received bachelor's degrees in computer science and economics from Carnegie Mellon University before attending Vanderbilt Law School, where he was an editor of the Vanderbilt Journal of Transnational Law. He practiced IP law in New York before moving to Japan and joined Sonoda and Kobayashi in 2018. He focuses on Japanese national phase prosecution of electrical and mechanical inventions and speaks both English and Japanese. So with that, I will turn things over first to Sarv.
Thank you very much. My name is Sarvajit Patil, and I'm happy to take you on this journey across the United States, Japan, Europe, and China to discuss how these laws are comparative to one another. First, a word on our firm. As you just heard, we were founded in 1998. We have over 100 specialists from several jurisdictions, many PhD holders, many languages and nationalities. So whatever your questions are in intellectual property, we're happy to help you with them. And let's see here. We have several, one of our groups is the Mechanical, Electrical Engineering, Information Electronics, and Telecommunications team. That's the team that I'm on. We have several areas of expertise here, including artificial intelligence, and that's what we're going to bring you today. First thing I want to do during this presentation is to talk about the laws in each jurisdiction, just give you an overview of them and a small case example from each of them. First Japan, then the United States, followed by Europe and China. And then we will do a comparative discussion of a case family that was granted in each of these jurisdictions. Starting with Japanese law. Japanese Patent Act Article 2 defines an invention as the highly advanced creation of technical ideas utilizing the laws of nature. The important phrase here is utilizing the laws of nature. How is this done and how is this interpreted? Now, the Article 2 further defines a computer program as a type of product that is patent eligible, which is very beneficial to those applicants who are interested in getting computer program patents. And a computer program, the definition here is quite broad. It includes not just what you may traditionally think of as a computer program, but equivalents to a computer program as well. The JPO tends to be generous on subject matter eligibility, as you can see above, but it's stricter on inventive step for software-related inventions. Now, utilizing the laws of nature, what does this mean? First, if the invention is fully regarded as utilizing the laws of nature, regardless of whether the invention includes computer software, the invention is a statutory invention and special considerations from the viewpoint of software are unnecessary. For example, if you're dealing with engine control, using software to control an engine, well, this engine that's moving, it's in the real world. You are actually using the laws of nature to control this engine. And so that would be considered to utilize the laws of nature. And this could be extended further to the example of image processing. Under Japanese law, an image that is a digital representation of something that exists or may exist in the real world is still considered to be utilizing the laws of nature. After this, we're going to deal with sound processing as well, and the same principle applies here. It's a representation of something that exists in the real world, and so processing on that representation is considered to utilize laws of nature. Now, in the case of something that's really specifically software in nature, we take a look at this fallback test. And the test here is to see if there's this cooperation between software and hardware resources. If an information processing apparatus or methodology is concretely constructed by cooperation of software and hardware resources, according to the purpose of use, this invention is deemed to utilize the laws of nature. And here we have this basically summarized into a flowchart. The left side represents things like engine control or image processing. On the right-hand side, we have things like mathematics or pure ideas that are not patentable. And when something doesn't fall clearly into one of these categories, we ask whether the characterizing part of the software cooperates with the hardware. If so, this is eligible subject matter. Now, when dealing with AI specifically, there are a few issues to note when we're talking about the written description and inventive step. Generally, when we're trying to figure out whether something is patentable, the most important thing for AI and software is subject matter eligibility. But pay close attention to these issues on written description and inventive step. First, if you're using your AI to develop correlations between two different data sets, then we really want to try to explain this correlation in the description, or at least it should be well known in the art, because if it's not supported in the description, the examiner is going to look to the relevant art. So ideally, support your correlations in the descriptions. You should have some explanation behind them. Otherwise, the examiner might give you a lack of support or lack of enablement rejection. Claims should not be generalized beyond features specified in the description. Of course, that would result in support or enablement issues as well. And if you have an AI that is trying to predict a model of something like a chemical, for example, you should try to produce that chemical, produce actual results of your AI predicted model. Otherwise, once again, the examiner might come at you with an enablement rejection. Now, regarding AI specifically, regarding inventive steps specifically, when you're dealing with AI or software in general, the person skilled in the art under Japanese law is considered to have expertise in both software and the field that you're applying that software to. So mere application of AI to a human operation or a known method would be considered within the skill of one of ordinary skill in the arts. Now, you may add inventive step by adding training data or pre-processing that training data in a creative way that was not previously known in the art. And that may add inventive step to your AI invention. And a lot of this information is available in English on the JPO website. I encourage you to check that out because it really is a useful resource. Now, the first example we're going to go through involves speaker verification. This was a Google case, and I'm going to be using this case for 3 jurisdictions, so I'll just explain it this once. This tries to verify whether a first speaker and that person's utterance, the voice or what they said, whether that utterance matches with a second utterance, and if you can determine from those 2 utterances whether these are the same speakers or whether they are different speakers. And as you can see from this figure, it uses a neural network to try to do the matching. And when you're training this neural network, you have labels so that based on whether the product, the output of the neural network matches with the labels, you can then adjust the neural network based on the error of that output. Now, here's some bibliographic information in case you need it. Like I said, this is a Google case, and it was filed in 2016 in Japan. It was granted in 2019, and let's skip right to the claim. Original claim 1, as you can see, this is a computer implemented method, a method claim and very much a software claim at its core. This involves, as you can see in the blue highlighted region, a neural network that has been trained based on a plurality of training samples. These training samples include data that characterizes a first utterance and data that characterizes one or more second utterances. Basically, the first user's voice, and then all the voices you're trying to compare that user to. And these are labeled so that you can determine whether these are matching or not matching for the purpose of tuning the weights in the neural network. Now, claim 1, let's see, there was a lack of novelty and or inventive step for this claim 1. However, claim 8 and 9 were not rejected. The fortunate thing for us is that we can see there is no rejection based on subject matter eligibility. So what the applicant did here was that the applicant amended claim 1 to include the features of claim 8. And the reason why there was no subject matter eligibility issue here is because, as we discussed before with image processing, sound processing is basically the same thing. It's using software to process something that exists in the real world and is represented as such in a computer. Sorry, let's see. Okay, so one moment, please. Okay, so as you can see, as amended, claim 8's features were included into claim 1, and it basically just tweaks it a little bit. Now it says that the training is done repeatedly more than once, and that a plurality of different utterances are provided from the first speaker instead of just being one or more. And we can see this is how the claim was amended. The Japanese examiner, of course, agreed with it because the examiner never found a reason for rejection for claim 8 in the first place. And so the Japanese claim was granted based on these features. Now let's take a look at an analysis of the subject matter eligibility here. Now, clearly we're dealing with software as the claim claims a computer implemented method. Without a doubt, this is a software invention. And as we discussed prior, software is patentable subject matter if it satisfies the requirements provided by the examination standards. Now, as you can see here, we're dealing with something that processes data relevant to a technical feature of the object, such as image processing or sound processing or something like that. And if you also want to take a look at this through the lens of cooperation between hardware and software, well, we have cooperation between the software, which is the neural network, and the computing device that receives the utterance and the microphone and all that other hardware that's used to capture the sound data. So we very clearly have cooperation between hardware and software. So now let's take a look at US law. I'm a US attorney, so I can explain this quite quickly, I think. Of course, if you have any questions, you can ask me later. The test that's used currently in the United States and has been in use since 2014 is called the Alice-Mayo test. This is a two-step test, and the second step is split into a step 2A and step 2B. Step 1 is the claim to a process, machine, manufacture, or composition of matter. This is generally a very easy question to answer, and it's a very easy problem to overcome if you have a problem. So generally, we're focusing on steps 2A and 2B. Step 2A is the claim directed to a law of nature or an abstract idea. If so, such as a software is often considered an abstract idea. Step 2B, does the claim recite additional elements that amount to significantly more than the judicial exception? And we're going to see a flow chart of this in just a second to help clarify what the yes-no thing is all about. But I also want to point out that last year there was a revision to the MPEP, which is the examination guidelines in the US. Section 2016.05A talks about improvements to the functioning of a computer or to any other technology or technical field. This is a consideration in step 2. Oh, I'm sorry. Let's see here. This is a consideration in step 2 where proof that's, oh geez, how far ahead did I go? Okay, there we are. This is where we see that, let's see, in step 2, when you're trying to prove that the additional elements of the claim amount to more than, significantly more than the judicial exception, improvements to the functioning of a computer, particularly in the case of software inventions, are really useful here to support that you are adding significantly more. Okay, so here's the flow chart of the Alice-Mayo test. As you can see, step 1, usually the easy thing to answer. If you're dealing with a software process, like a method in a software algorithm, you move directly to step 2A. Now, are you dealing with an abstract idea? And software is often considered to be an abstract idea. So you would move on to step 2B. Does the claim recite additional elements that amount to significantly more than the abstract idea or the software algorithm? If so, the claim qualifies as eligible subject matter under Section 101 of the US law. Now we're going to take a look at the same example here. Once again, we have two utterances that are going to be matched with the use of a neural network. Here's some bibliographic information once again, and this was issued 2 years ago. Here's how the examiner applied the Alice-Mayo test. Claims 1 to 6 and 22 to 23 are directed to the abstract idea of evaluating a speaker representation. No surprise, since we're dealing with software, it's often likened to an abstract idea. But is it something more? And here the examiner says no. These procedures and steps can be categorized as organizing information through mathematical correlations and is therefore considered an abstract idea. And unfortunately, the claims do not include additional elements that are sufficient to amount to significantly more than the judicial exception. The computer device, memory, processor, these are all recited at a high level of generality and are recited as performing generic computer functions that are routinely used in computer applications. So simply reciting memory or a processor, it's not enough for under current US law. Let's see now, let's try this one more time. Okay, so in response to this office action, the applicant explained several technical advantages that can result from training the neural network. And among these technical advantages are increased accuracy for speaker verification. And the examiner was actually convinced by these arguments. The examiner decided that based on these technical advantages, we are dealing with something significantly more than simply an abstract idea, and it does in fact improve the use of a computer. So there was one more office action dealing with obviousness, but we don't need to get into that here. And the applicant had to overcome that obviousness issue, had to make significant amendments, but the subject matter eligibility was dealt with in the first office action, and ultimately this was issued. So let's talk about this. In the past, in the United States, if you were dealing with subject matter eligibility for software, your strategy was often just to say, this uses a processor, or this is stored on a computer readable, non-transitory storage medium. But those magic words really aren't effective anymore. If you just have those generic terms, you're unlikely to overcome these subject matter eligibility rejections. And now something that I think is kind of funny, are technical effects suddenly important in US examination? Typically, when you're trying to argue for technical effects in the United States, they're just considered a secondary consideration. I know in Europe and Japan, technical effects are more important to argue in your responses to office actions, but not really in the US. It never really has been. But now, at least for subject matter eligibility, it may be useful in establishing that claimed elements amount to significantly more than an abstract idea. So you may want to include that kind of information in your specification in the US. Now let's take a look at European law. According to Article 52 of the EPC, the following in particular shall not be regarded as inventions. This includes programs for computers, also mathematical methods, and presentations of information. So unlike the Japanese patent law, which specifically allows computer programs as eligible subject matter, the US, the EPC rather, specifically excludes it. But if we take a closer look at the patentability requirements under Parts G and Part B of the EPO guidelines, we'll see that there are some exceptions. The invention must be of technical character to the extent that it must relate to a technical field, must be concerned with a technical problem, and must have technical features. Now, features that appear to be non-technical when taken in isolation may nonetheless contribute to the technical character of a claimed invention if, in the context of that invention, they contribute to produce a technical effect serving a technical purpose. So here you see there is some leeway, and you may be able to use your AI software to contribute to the technical character of the invention. All right, and actually the EPO has some guidelines specifically for artificial intelligence and machine learning, particularly the last paragraph here. Where a classification method serves a technical purpose, the steps of generating the training set and the training of the classifier may also contribute to the technical character of the invention. which otherwise may be considered just AI, support vector machines, neural networks, genetic algorithms. These sort of things by themselves may be considered devoid of technical character. And here's a simple flowchart to help illustrate this. First question is whether these mathematical method programs or computers or presentations of information are inventions as such. If not, if it's something more than that, does the claimed subject matter have a technical character? If so, you will analyze novelty and inventiveness assessed only to the technical features of the invention. And we're once again going to look at the speaker verification case. So here's some information about that case, some of the examination history. And in this case, we're actually going to deal with a slightly different claim 1 because due to European procedures, the applicants decided to cancel the claim 1 that we saw before and replace that with what was claim 7 here. We're also going to look at claim 13 because that's interesting for the purposes of this discussion. Claim 1, a computer implemented method comprising determining a speaker model, determining a speaker representation, comparing the speaker representation with the speaker model, and adjusting the neural network. This part is very important because, as we saw before, training the neural network may be considered to contribute to the technical character of the invention. So this specifically recites adjusting the neural network. Now let's take a look at Claim 13. Claim 13 is also a computer implemented method. However, this recites receiving an utterance, generating a speaker representation for the utterance, accessing a speaker model, and evaluating the speaker representation for the utterance. Now this, according to the examiner, does not specifically claim the steps of adjusting or training a neural network. It simply recites using a neural network, such as the one in Claim 1. Now, there was no problem with Claim 1. That subject matter was allowable. But there was a problem with Claim 13 in Europe. The subject matter of this claim does not comprise any training steps and only attempts to characterize the neural network by its alleged generating process, resulting in a lack of novelty and inventive step. So as a response, the applicant amends Claim 13 to try to include the features of Claim 1. However, it was already dependent on Claim 1, or at least it would already referred to the features of Claim 1. So this really didn't accomplish anything in the view of the examiner. As you can see here, they basically just copied over the features of Claim 1 into the new Claim 13. However, once again, the examiner says that the claim method does not comprise the specific steps involved in training the neural network. It just says use this network and also includes some information on how the neural network is trained. But for the purpose of examination, it does not comprise the specific steps involved in training the neural network. So Claim 13 lacked novelty, and ultimately, these claims had to be canceled. Claims 1 and 2 only remained for the patent to be granted. So now Claim 13 was rejected despite incorporating seemingly identical subject matter to the corresponding Claim 1. And I think perhaps in Japan or the US, there would have been no problem with this, but in Europe there was. According to the second office action, the claimed method should comprise the specific steps involved in training the neural network, kind of as we saw in the EPO guidelines. Where a classification method serves a technical purpose, the steps of generating the training set and training the classifier may also contribute to the technical character of the invention if they support achieving that technical purpose. Okay, now let's look at Chinese law. Eligibility under Chinese law, Article 25. If a claim concerns only rules and methods for mental activities, it shall not be granted a patent right, and computer programs are an example of this. And while a computer program itself does not qualify for protection, a medium plus a computer program is eligible for protection. And under Part 2, Chapter 9, we'll see that a criterion of functionally supportive and interactive was established for novelty and creativity. What does this mean and why is it so relevant for software? Well, the term functionally supportive and interactive means that the features of the algorithm or the features of the business rules methods are closely coupled with the technical features, jointly constitute the technical means to solve a technical problem, and are capable of achieving the appropriate technical effect. From this, we can kind of see the analogy between the US and Japan. This kind of looks like cooperation between hardware and software, or technical, trying to solve a technical problem and contributing to the technical character under European law, perhaps. You can see that all of these are actually more similar than you might have imagined. And finally, the claim should be examined as a whole to analyze AIM's technical problems. This was part of a recent revision to the Chinese patent law. Here we can see newly amended guidelines that went into effect as of February 1st, 2020. When assessing novelty or inventiveness of a claim, all features, including both technical features and algorithm features or business method features, should be considered as a whole. And on the basis of technical features, algorithm features or business method features should support each other and interact with the technical features. So this appears to be a very holistic approach to assessing the technical character of the subject matter. And this appears to be very favorable to applicants looking to get AI or software patents. Now here's a quick flowchart to demonstrate this, whether or not the claim recites only a program. If it's only a program, it's not eligible. However, if it's stored on a medium, then we move on to the next step, whether or not the algorithm features or business method features constitute a technical solution. And this is done viewing the claim holistically. If so, all features, including both technical features and algorithm features or business method features, are considered as a whole when assessing novelty and inventive step. So here is a related case. It's not the same case as before. That case is still pending in China, but this is a case with similar subject matter regarding speaker verification. As you can see here, this is a neural network, and the goal of this neural network is to decide whether an utterance by a speaker either matches the target speaker or not. And we're not going to get too much into the technical issues with this case, but we're going to take instead a look at the storage issue, the storage in a medium issue. Here we have in Claim 15 a non-transitory computer-readable storage medium. Obviously, this is for storing the computer program. And under Chinese patent law, that should be eligible. However, at the time this was filed in 2017, February of 2017, this was not yet part of the law. So even if the computer programs were stored on a medium, they were still not necessarily eligible. However, between February 2017 and May 2017, you can see on April 1st, 2017, the guidelines were revised to say that medium plus computer program is eligible for protection. And so the examiner accepted this argument because the law had changed and granted the patent after some more inventive step issues overcame some of these other issues. But as you can see, as for any lawyer, patent lawyer, criminal lawyer, whoever you are, always be aware of the most recent law because it really helped out in this case. The patent attorney knew that the law had changed, made the appropriate arguments, and got their claims allowed. And we have seen that there is also some new guidelines in China effective as of February 1st, 2020, which may seem like a very long time ago, but it's really quite recent. And so if we try to take a look at this case under the most recent guidelines, I expect that we would achieve the same result because the most recent guidelines stressing that the claim should be viewed holistically, the technical and non-technical features should be viewed as a whole. This would only be more favorable for the applicant. So we would at least get the same result here, if not better. Okay, and now we are going to get to the main case study from a case that was granted in all 4 jurisdictions. This is a deep learning neural network learning method and apparatus and category independent subnetwork learning apparatus. That sounds like a mouthful, but it's actually not so bad. If you take a look at this picture on the right-hand side, it's basically just a neural network with 3 different parts. There's an independent subnetwork. This is for speech processing and speech recognition, by the way. So there is an independent subnetwork that would take input in more than one language. In this particular example, the language could be Japanese or English. So it will accept this language independent input. It could be Japanese, it could be English, and it will do processing that is common to both Japanese and English. Once this common processing is done, then if the language is Japanese, you'll move on to the Japanese dependent subnetwork for processing of Japanese language. And if it's English language, then you will move on to the English dependent subnetwork for processing that is specific to English. The idea here is that if you have 2 different neural networks, one for Japanese and one for English, those both together would take a long time to train. However, if you train some of the common features in the independent subnetwork, you would reduce the training time and perhaps the complexity and increase the efficiency of training. So let's look at how this took place in Japan. This was originally a Japanese application. And to remind you, the Japanese approach here is to consider whether or not the claim subject matter utilizes the law of nature. And the fallback test here is cooperation between hardware and software. And remember that Japan can be very forgiving on subject matter eligibility, but may be stricter on other factors such as inventive step. Okay, some more information if you want to look over this on your own time. This was granted 3 years ago. Like I said, this was first filed in Japan back in 2013 and then made its way to other jurisdictions from there. Now, taking a look at the claim language here, we can see that we're once again dealing with a deep neural network method. This is a method claim. And further, you can see in the later claim language, we're claiming first, second, and third subnetworks. Those are the common English and Japanese subnetwork, then there's the Japanese specific subnetwork and the English specific subnetwork. And later on, the claim basically describes how these networks are connected to each other, such that the output of the common network is the input for the specific networks. We're also going to look at Claim 5, which recites a data storage medium storing parameters. Remember this part, storing parameters of a subnetwork of a deep neural network learned by a method according to any of Claims 1 to 4. Now, as we might expect, there was no reason for rejection for Claim 1 here. Subject matter was not an issue because Japan isn't going to give you an issue about this. As we saw with the previous speaker verification case, this involves speech processing under Japanese law. This is very clearly eligible subject matter because it's processing a representation of something that exists in the real world, therefore utilizing the laws of nature. Claim 5, on the other hand, relating to the storage medium that stored the parameters of the network, this at first was said to lack inventive step. The applicant actually successfully argued that it did have inventive step without having to make any further amendments. However, with the second office action, this is actually where the examiner first comes back with a rejection saying this is not eligible for a patent, because simply storing parameters, simply storing these characteristic features of data in memory, that is not subject matter eligible. This is similar to mere presentation of information, such as storing audio on a CD or storing an image on a digital camera. There's nothing really, there's no reason to make this eligible, simply storing parameters from neural network. So here's how the applicant tried to overcome this. They tried to remove parameters, and instead of saying storing parameters of a subnetwork, they said storing a subnetwork, just storing the whole subnetwork on the storage medium. Now, in this argument, the applicant tried to say that now that you're storing the entire neural network or the entire subnetwork on a storage media, now you're dealing with software. As we saw before, when dealing with software under Japanese law, a software includes software equivalence. So if the claim invention is deemed to be software in view of the description in the specification, the drawings, common knowledge of those skilled in the art, the claim must be examined as software. And if you're one skilled in the art, you may consider that a subnetwork of neural networks stored in memory would be software. That's kind of a common sense reaction, right? Well, the problem here is that the process performed by the subnetwork was not specified. And so the applicant decided to delete Claim 5 before the examiner granted the application. So let's consider this issue of eligibility of a data storage medium. Like we said before, if one would consider this the equivalent of software, it should be eligible for a patent. And software is patentable subject matter if it satisfies the same requirements that we described before. Once again, we're dealing with speech processing. So this processes data relevant to a technical feature of the object. However, the issue here did not appear to be one of subject matter eligibility, but rather whether there was sufficient support or enablement in the description to support the new claim. Now, storing parameters in memory, that was supported by the specification, but was storing the whole subnetwork supported by the specification? It didn't appear to be here, and that's why there was a rejection. If there had been proper support, then we think that subject matter eligibility would not have been a problem. I'm sorry, let's see here. Okay, so now let's move on to the US equivalent of this case. Taking a look at this under the lens of the Alice-Mayo test, once again, we're looking to see if there is a process here. As this is a software claim, it involves a process. So we move on to step 2A. Are we dealing with an abstract idea here? Most likely, since we're dealing with software, we're most likely dealing with an abstract idea. And then we have to ask, looking at the claim elements, are they significantly more than the abstract idea? Okay, we can see that this, okay. Step 1, is a claim to a process? Yes, the method is a process, no problem there. Step 2A, determine whether the claim is directed to an abstract idea. And unsurprisingly, the examiner said, yes, claim 1 is directed to an abstract idea using these neural networks in such a manner. Now, step 2B, this is the interesting part. Determine whether any element or combination of elements in the claim is sufficient to ensure that the claim amounts to significantly more than the abstract idea itself. And while the examiner says it does not amount to significantly more than the abstract idea, the examiner actually makes a suggestion about how this step may be satisfied. Okay, so the examiner says, okay, the recited method provides for training a deep neural network. The examiner finds this underlying idea to be abstract because it deals with information and algorithmic steps independent of any physical or concrete embodiment. This is not surprising because we're dealing with software and neural networks here. So now, how are these being limited to concrete examples? Well, the claims only had generic computer implementation. We saw this with the other American case we looked at as well. They were just talking about a computer and a storage medium. There was really nothing unique about these. They were just generic routine computer uses. And the examiner notes that this rejection can likely be overcome by directing claims to either of the real-world problems of automatic speech recognition or image recognition, as discussed in the technical field, which apparently also included image recognition. But here, of course, we're mainly dealing with speech recognition. And this is, in fact, how the applicant decided to amend the claims. They said that instead of simply a method, a computer-implemented method, they changed this to a training method for speech recognition. And instead of simply identifying objects, they changed this to identifying speech objects. And they also threw in some of these magic words we discussed before, a non-transitory computer-readable medium and a processor. But as we discussed before, those probably didn't really help much. So the applicant ultimately argues for non-obviousness with some minor amendments. There are no further office actions, and the patent was eventually granted. So let's talk about this. Directing claims to real-world problems. This is what the examiner wanted the applicant to do here. And previously, we were only dealing with identifying categories and categorizing objects. These things are all quite abstract. So once you narrow this down to, instead of categories, you have languages. Instead of objects, you have speech objects. This is getting more and more concrete, and this is where the examiner decided this was sufficient for subject matter eligibility. Now, regarding generic computer implementation, as we saw with the previous case, this in and of itself was not enough, because as originally written, the claim talked about computers, it talked about memory, but that was not enough. So you may want to recite more specific computer implementations on top of that, if necessary. Now let's take a look at the European side of the case. Now, the European approach is, when assessing inventive step, consider all features which contribute to the technical character of the invention. Non-technical features may contribute to technical character if they produce a technical effect serving a technical purpose. And the steps of generating the training set and training the classifier may contribute to the technical character of the invention if they support achieving that technical purpose. Okay, so here's bibliographic information once again if you want to review this later. And the pre-examination history here is not particularly exciting, so we'll skip straight to the first office action. Okay, so this was just granted earlier this year. Examination started last year. This is basically the latest law. Okay, first office action. The applicant's claims do not introduce such a concrete technical purpose, but remain at the more general level of abstract objects and categories. This is kind of similar to what we just saw in the US. Objects and categories are kind of abstract, but what if you narrowed this to speech and languages? Well, here's what the examiner said. Without any concrete technical meaning of categories and objects and the type of data as well, the respective features remain abstract, and this difference has no technical effect. As indicated previously, the above method concretely directed to learning to recognize speech, in which the two categories are two different languages, and in which to train two different languages at the same time by sharing a common subnetwork, that would be inventive over the prior arts. So in the response to the first office action, the applicant decides to change categories to different languages. Would this be enough? Apparently not, because the examiner came back and said that, sure, you've defined languages, but what about objects and what about data? These features still need to be clearly defined in order to extract a concrete technical meaning. So here there was the issue, okay, of would you be called in for oral arguments or not? The applicant decided to amend one more time. And here we can see that they changed a method of learning to identify objects to a method of learning to recognize speech. This is much more concrete and also similar to what they did in the US. Instead of objects, they changed this to speech. Instead of distinguishing object, you're distinguishing speech. And with regard to data, instead of training data and the data, they're training speech data and talking about the speech data belonging to first and second categories. So here we see various aspects being trying to make these aspects more concrete. Now there was another interview here, and ultimately with these changes, the examiner allowed the patent. So let's talk about this. How concrete must claim language be? At first, they just said categories and changed that to languages. The examiner said that wasn't enough. If we take this further and do what they did in the US, categories was changed to languages and objects was changed to speech. That was enough for the US, but in Europe, the examiner in the office action also said that they wanted to see data changed. So here we have speech data instead of data. And of course, how much support is needed for these amendments? Because of course, you can keep getting narrower and narrower, but of course you lose the breadth of your patent, you lose the power of your patent. So if you want to be able to make just minor changes or perhaps incremental changes from abstract to concrete, please make sure you have plenty of support in the specification to be able to do this. And in fact, perhaps if the examiner decided that speech and objects were not sufficiently connected in the specification, maybe they would have lost subject matter eligibility altogether. So be very careful that you have enough support in your specification to turn a more abstract concept into more concrete implementation. And finally, let's take a look at the Chinese side of the case. Once again, we have subject matter eligibility not for a computer program itself, but a computer program plus a medium that it's stored on. And the new standard, as we saw in the guidelines effective February 2020, all features in the claim should be considered as a whole. Now, bear in mind, of course, this did go into effect after this application was granted. So we're going to see the examiner here being a bit more strict on mathematical or algorithmic features. But keep in mind that, if anything, based on the new standards, it would likely be more favorable for the applicant here. And the examiner would probably be less strict about separating the mathematical features from the technical features. Okay, so once again, we're dealing with some bibliographic information. So if you want to look over all this, you can do that on your own. And this was 2 years ago, so clearly it's not using the latest standards. Unfortunately, since it was just released earlier this year, it's hard to find cases about that, but we can try to imagine how those standards might apply to other recent cases. Once again, we're dealing with a very similar claim language, just modified slightly for the Chinese format, dealing with a deep neural network learning method, and once again with first subnetwork, second subnetwork, and third subnetworks stored, and using those to learn how to categorize different objects, not speech, but objects. Now, in the first office action, it was decided that there was a lack of inventive step. The examiner here said the contents and steps of the deep neural network learning method are essentially mathematical calculation methods. The use of these methods does not result in inventive improvements to the system, and so those would not be considered in evaluating novelty and inventive step. So the technical solution as claimed in Claim 1 does not have outstanding substantive characteristics and remarkable progress, even though the examiner does admit that Claim 1 differs from the primary citation in their specific embodiments. It's just that the difference is only limited to a mathematical calculation. So in response, the examiner, the applicant at first, does not make any amendments and simply argues that there is a technical effect here. The present invention works on the actions of a computer, whereby the time required for such learning can be shortened. That is a technical effect, isn't it? So shouldn't we consider the technical character in assessing novelty and inventive step? Well, the examiner comes back with the second office action saying, well, yeah, if you read the application, we can see the object of the present invention is to shorten the time for learning in the deep neural network. However, the essence of this application is that only one mathematical operation is performed using a computer and its associated components. So this is not enough to satisfy the subject matter eligibility necessary to consider these in evaluating inventive step. However, the examiner comes forward with a suggestion. The learning method of the deep-seated neural network can be applied to voice recognition and can achieve the technical effects of improving voice recognition efficiency. So if it's amended like this, it should be allowable. And the amendments were made consistent with the examiner's suggestion. The categories were changed to languages, as we kind of saw with the US and Europe. Sound data replaced objects. So we see a lot of the same sort of amendments here as we did in Europe and in the US. And finally, it's determined that as a result, the learning method of independent claim 1, after incorporating the sound recognition field and related technologies in the embodiments into the claims of the application, is not only a mathematical operation. It's more than that, and so it should be considered when evaluating novelty and inventive step. So the examiner does this and agrees that the patent should be granted after one more office action that's related to clarity and not necessarily relevant for our discussion today. And here we see, in this case, the examiner originally stated that claim 1 differs from citation 1 only in that a mathematical operation is performed using a computer and its related components. The use of these methods does not result in inventive improvements to the system. It was just too abstract as a mathematical operation. But if you take a look at the revision that was made on December 31st last year and went into effect on February 1st of this year, the examiner must consider the characteristics of the algorithm's business rules and methods in determining novelty and inventive step. Would that have produced a different outcome in this case? Perhaps yes. If anything, it would have been easier under these new standards to obtain, to at least have obtained subject matter eligibility and the patent earlier, because the claim would have been viewed more likely as a whole, and the examiner would have been less likely, perhaps, to separate the mathematical components from the other technical components. So some conclusions from this case study here. Despite having 4 different approaches in these 4 different jurisdictions, all jurisdictions except Japan require the same sort of narrowing, in that they require narrowing of the claim language to recite the application of speech recognition and not merely identifying objects and placing them into different categories in a more abstract sense. So it's kind of funny, when you see all these different laws on the books, you see how they're written, you would think they would necessarily result in different conclusions, but actually 3 of these 4 jurisdictions resulted in very similar final claims. Now, China required perhaps the most amendments, but under the new standards, all of these amendments may not have been necessary, and the final claims may have looked more like they would have in the US or Europe. And finally, I cannot stress this enough, perhaps, support is crucial in case it is necessary to narrow an abstract idea to a more concrete technical application. We saw this in a few jurisdictions, and not just with this case, but in the previous speaker verification cases as well. If you don't have proper support to reduce a more abstract idea to a more concrete application, then instead of a subject matter eligibility rejection, you're going to get a support rejection, and either way, you won't be able to get a patent. So make sure that support is very, very important. Okay, thank you all for listening, and let's see if you have any questions. First of all, you can access us at info@patents.jp. Our website is patents.jp. We're based in the center of Tokyo, so if you're ever in the neighborhood, come and stop by. And we have Dr. Sonoda with us, so if you have any questions about Japanese law, feel free to ask those. I'll answer questions the best I can. And yeah, go ahead, please.
Well, thank you very much, Sarv. That was fascinating and quick trip around the world. And like you mentioned, we do have Dr. Sonoda on hand to answer your questions. So this is your chance. Unfortunately, you can't ask questions via audio, so what you need to do is click, there's a little tab on GoToWebinar that says questions. You'll be able to type in your query there, and if we can get to it, we certainly will. As a first question, we have a question about Japan. So can you tell us anything about how many AI-related applications you're seeing come through the JPO, and so how many sort of examiner decisions we have the benefit of looking through for guidance?
So may I answer the question? This is Sonoda.
Yes, please go ahead.
Yeah, It's a pretty difficult question because it depends on the definition of AI-related invention. However, it is certain that the number is rapidly increasing, and according to we did our own statistics about the AI inventions, and the criteria we used was the invention wherein the either title or the claims use the word the artificial intelligence or deep learning or some related words. And there are about 1,000 applications published in 2019. The number is increasing, and we expect that the number will become higher this year.
Okay. We have a second question here, and this comes from a questioner who appears to be working in a university technology licensing department. So the question is, any tips for claim strategy on more fundamental machine learning inventions in a university case? Typically, the inventions at a university are framework or platforms for several applications that have yet been untested or just basic testing and data has been gathered. So tips on the claim strategy for those types of inventions.
Oof, that's a difficult question. There is no easy answer, I believe, because the situation relates to both inventive step question and enablement question. The basic idea to satisfy these requirements is to be persuasive in front of other researchers regarding the advantageous result obtainable by the invention and the feasibility of the invention, the feasibility including to perform the invention and obtain the advantageous results. And if you have, or to have a concrete test example is a relatively easy way to be convincing regarding these two aspects. However, it is worth noting that to have example is not an absolute requirement. So as long as you can explain your invention without these concrete examples, why you can expect these advantageous results and how other people can perform the same invention. And I know this answer is quite abstract, but we are happy to see the situation based on the data and have more discussions if necessary.
Okay. We have another question here. Is AI considered as an inventor in any of the jurisdictions? So AI as the inventor of a patent.
Yeah, there that question since some time ago, and there are discussions in Japan, and we have not yet have a concrete idea whether we should accept the AI as an inventor. We will need more time to have more concrete answer.
Okay, and if I may add, this is Sarv speaking once again. There was recently a decision in the United States saying that in the United States, AI cannot be an inventor. And according to our European colleague, this is also the case in Europe, that AI cannot be considered an inventor from a case back in January of 2020.
Okay. It looks like we have a question about whether there are AI-related incentives in the countries you talked about. Are there any incentives for or special considerations for filing AI-related patents in any of the jurisdictions that you're aware of?
Maybe I can find an answer later.
Sure. We have another question that we can move on to. Do you think that the EPO practice of assessing eligibility, quote unquote technicality, make it hard to have an AI invention be granted in Europe as compared to the other jurisdictions?
As a practitioner familiar with the Japanese practice, I have a personal impression to say yes.
Mm-hmm.
But maybe other people may have some other opinions.
Mm-hmm. Sarv, anything to add on that point?
I would have to agree with Dr. Sonoda here. I mean, of course, I've never practiced in Europe, but on paper, it certainly seems harder based on the cases we saw. However, it actually may not be as strict as one would think, but still perhaps stricter than the US and Japan, for example. Yes, I do think it makes it harder, but if you take a look at the EPO guidelines, they actually did have a specific section on AI and machine learning. So it appears that in Europe, they do view AI and machine learning as something that they want to encourage. And because of that, they may try to make the restrictions a bit more lax. Still, though, I think that it is a bit more difficult in Europe than other jurisdictions.
Mm-hmm. Yeah, you mentioned the AI-specific guidelines or examples put out by at least the JPO has put out very detailed things in English, as well as the EPO. I just wonder, Sarv, have there been any AI-specific guidelines put out by the USPTO?
I haven't seen any AI-specific guidelines from the USPTO. I'm aware that there was a conference about AI hosted by the USPTO. I believe it was last year, but I don't know that anything specific has come out of that in terms of law or guidelines. But it is certainly on the USPTO's radar.
Mm-hmm. Are there things, as a U.S. practitioner, are there, particular areas that you think could benefit from being cleared up by the kinds of examples that have been produced by some of the other offices?
Let's see, that's a good question. Ultimately, these cases come down to the Supreme Court in the United States. Like the Alice Mayo test came down from a Supreme Court decision. And so if there is going to be any legislative change, the America Invents Act was back in 2011, I want to say. The Alice Mayo test was back in 2014. So yeah, sure, there are good ideas from other jurisdictions, but given that recent changes to the law, both from the Supreme Court and from Congress, have come fairly recently, I don't expect that any other developments are going to come about in the near future. Now, with that said, I do think that, let's see. Yeah, some of the clarifications from actually the Europe of all things might help out. Some more guidelines about AI and machine learning in general, because I don't believe there are any guidelines specifically regarding AI at this moment. But at least if they would publish something on the topic, that would perhaps be helpful.
Mm-hmm. We've had a question come in asking about sort of harmonization, given that there were sort of diverse decisions that you've talked about today and the number of different stakeholders involved. Do you think that things are moving at all in a direction toward harmonization in these areas, or is there still a ways to go?
And there is always the effort to harmonize the laws and also examination standards and interpretation of laws. But because the AI-related inventions and how to examine those inventions are relatively new, for the moment, the standards are somewhat different between jurisdictions. But I believe that people will try to have harmonized standards.
Mm-hmm.
But it will take some time.
And maybe finally here, we have a question maybe for Sarv. In the US, are there any art units to try and avoid 101 rejections? Is it possible to suggest more favorable art unit to evaluate AI case in spec?
That's a good question. It's been a while since I've practiced in the US, so I'm really not up to date on my art units, but we actually have recently had a former examiner, a former USPTO examiner, join our firm just a few months ago. So I could forward that question to him and have him give you an answer if you would like to email us this question once the webinar is over.
Okay, well, so summing up from both of our speakers, is there anything else that we didn't get to that you'd like to add in conclusion?
It seems like I think we've covered a lot of material in this webinar today. Of course, this is going to be online later, so you can feel free to look at this in more depth and analyze some of these cases for yourself.
All right, thanks so much. So you're right, we've covered a whole lot of ground in just an hour, but the clock is working against us. So I'd like to thank both Dr. Sonoda and Sarvajit for an excellent presentation, jam-packed with information. Just another reminder, as Sarv mentioned, we will be sending out the link. You can share that with colleagues, so please keep an eye out and spread it far and wide. And thank you all for participating, and we do hope that you join us again for another Lexology webinar in the future. Thanks, everybody.
Thank you.
Thank you.